Yes, hello, good afternoon, and thank you for joining us for our latest Law Lab session. For those of you I haven't met, my name is Anna Reid. I'm a Senior Associate in our Employment team, and I'm joined today by my colleague Carol Lowe, who is an Associate in the team. The topic of today's Law Lab is the effective use of probationary periods and why this is now far more important than previously. Cara will then take you through some recent legal updates. Just before we get started, a few housekeeping points. Please keep yourself on mute for the duration of the session. It just limits the background noise for us. If you do have any questions, do just pop those in the chat function, and we should hopefully have time at the end to cover those. We can't give specific legal advice in the call today, so if you do have any queries about particular scenarios, please do just get in touch with us or your usual Brignispel contacts. And finally, we're recording the session today. Any questions, you can see the privacy notice on our website. So turning to look at probationary periods. Probationary periods have no legal definition. They're not set out in any legislation. There's no legal obligation to have them, but they are found in the vast majority of employment contracts. However, we do tend to find that whilst employment contracts usually contain them, they're very often not properly implemented in practice. They're not actively managed, and things can be let slide past the end of the probationary period with no assessment actually being made. There is, of course, little value in there being a probationary period in the contract if they're not effectively used in practice. And the effective use of these is, as I say, from this year, far more important. And that is with a key change to come into effect from the 1st of January 2027 under the Employment Rights Act 2025. That change is that the qualifying period of service to bring an unfair dismissal claim is to be reduced from the 2 years, which it is currently, to just 6 months. This means that any employees that have at least 6 months service as at the 1st of January next year will have ordinary unfair dismissal protection from that date. As the law currently stands with the 2-year qualifying period, that initial 2-year period of employment, it's effectively like an extended probationary period for employers, in the sense that if performance issues are not appropriately addressed in the contractual probationary period, then provided that there's no discrimination or other day one claims, which we'll touch on, the employer can still dismiss the employee for performance or conduct issues without a performance or disciplinary process at any time during the first 2 years, without this giving rise to an unfair dismissal claim. But with this change, that will of course no longer be the case. Any performance-related dismissal taking effect after the first 6 months will be unfair without a proper performance management process. Such processes, I'm sure you're all well aware, can be very protracted, involves at least 2 warnings, reasonable periods to improve following each warning, with the support in place to do that, usually via performance improvement plans. So it generally takes months and months and can take up a lot of time for both managers and HR. Similarly, any dismissal for conduct after that 6-month period will be unfair without a full and fair investigation and disciplinary process, and other than in cases of gross misconduct, previous disciplinary warnings. To add to this, under the Employment Rights Act 2025, the cap on compensation in ordinary unfair dismissal claims is to be removed. So the stakes can be higher if you do get it wrong with a performance or conduct dismissal where the employee has that 6 months qualifying service. The compensatory award, which can be paid in addition to the basic award, it's currently capped at the lower of a year's pay or £120,000. That will come away, so there will be no limit on the compensation that can be awarded for unfair dismissal. So with that in mind, if you've got performance or conduct issues with new starts, you really want to be addressing them head on this year before the qualifying period reduces at the start of next year. And effectively managed probation periods will be key in mitigating the risks where the employee is not the right fit for the role. Of course, it's not all negative. Probationary periods can be a great chance for the employee to get to know the organisation and its culture, build rapport with their manager, and feel motivated and well supported in the early stages of their career with you. As an organisation, you've invested a lot in hiring someone, you want it to work out, and probationary periods can be a really good opportunity to set employees up for that success if they are effectively managed. So what are the key things to bear in mind to ensure the effective management of that probationary period? I'll run through our top 10 tips on that. So moving to tip number 1, which is review the probationary periods in your current template contracts. Importantly, consider whether they need to be shorter. We probably most commonly see 6-month probationary periods, I would say. But going forward, we would certainly recommend shorter than this. I would say 3 months, or at absolute most 4 months, with a limited ability as employer to extend by, say, no more than 1 month. And this is to make sure you have time to assess the performance at the end of the probationary period and make a decision before the employee hits that 6-month mark and gets qualifying service for unfair dismissal. Something else you might want to check is that your contracts provide for a shorter notice period during the probationary period in order to minimise the costs to the business if things don't work out. We most commonly see just 1 week, which is the statutory minimum notice for employees with between 1 month and 2 years service. Moving to tip number 2, which is set expectations clearly at the outset. So ensure that it's clear to new starts what their role involves and what the expectations are, and that you have a comprehensive induction to help them to get to grips with their role. The sooner you do this, the sooner it'll allow you to assess their performance. It can be helpful to set clear objectives and goals. If they have targets or KPIs, this should be made clear to them at the outset. And information provided to them on how they can achieve these. Things like making sure they know where to find things and that they feel able to ask questions. This is all going to be really useful to the employee as well and should hopefully help them settle into their role and gain confidence in it. It's also helpful to make them aware of what the review process is, so timescales for review, whatever the dates for check-ins, review meetings are, so that they know what to expect from their probationary period. And that leads us on to the next tip, which is to have regular meetings. I'll just move to the next slide there. So right from the get-go, managers should be having regular catch-ups with employees to monitor what they're doing well and identify any problem areas. At a minimum, you're probably looking at maybe once a month, but it can be helpful to meet more frequently, maybe perhaps shorter weekly check-ins to discuss how they've got on the past week, what they've got coming up that week, and then a lengthier monthly meeting to go through things in more detail, like looking at the employee's performance against each of their objectives. I know this is the type of thing that can get pushed to the bottom of the to-do list when managers are busy, but it really can save time in the long run. Moving then to tip number 4, be aware of day 1 rights. So just because in the first 2 years, soon to be only the first 6 months, an employee cannot bring an ordinary unfair dismissal claim, this certainly does not mean that there's no legal risk in that period. This is because there are, of course, other claims to be aware of that an employee has the right to bring without any minimum period of qualifying service. One in particular to be careful of in this context is discrimination. Employees do not need any minimum period of service to bring a discrimination claim, and compensation, if they're successful, is uncapped. So some examples of where a discrimination claim can arise in the context of probationary periods are where an employee is terminated for a failed probation, but their performance or conduct was impacted by, for example, something arising from a disability or pregnancy, or where they have been absent during their probationary period for a disability or pregnancy related reason, or for maternity leave or other family leave, and the probationary period has not been appropriately extended. A disability discrimination claim can also arise where an employer fails to make reasonable adjustments during the probationary period for an employee whose disability somehow puts them at a substantial disadvantage compared to others. There are also a range of other day one claims an employee may have where they can persuade a tribunal that the termination of their employment purportedly for performance or conduct reasons was in fact for another protected reason. So that could be a discriminatory reason, so where they say they were actually dismissed due to one of the protected characteristics under the Equality Act. But there are also various other protected reasons out with the Equality Act. This includes where an employee can show that the real reason for their dismissal was, for example, them blowing the whistle or asserting certain statutory rights. Moving then to tip number 5, keep HR oversight if possible. So where managers do have concerns during the probationary period about the employee's conduct or their performance in the role, you might wish to encourage them to bring these to HR attention at an early stage. This will not only allow you to help them identify whether there are any risks of these day one claims I mentioned, but it can also help allow you to help them guide them through the process, and can help to ensure a consistent approach across the organisation, which can build trust in the process and can also mitigate the risk of discrimination claims. Moving to tip number 6, which is make sure that any areas for improvement are promptly and clearly communicated to the employee. This one's really important. I think it can be tempting for managers to shy away from this. Giving constructive feedback can be really difficult, but it is absolutely key to effectively managing the probationary period. Now, of course, discussions around this should be delivered sensitively and respectfully, but it's really important that managers are clear with an employee about where they're not meeting the required standard, and not just general broad criticisms, but rather specific concrete examples of underperformance and, where possible, targets for improvement. And approaching it in a supportive manner, keeping it factual and objective, and asking the employee what support they feel they might need to achieve what the business is looking for. There are, of course, a number of benefits to addressing issues promptly and clearly. If you can properly deal with issues early, you stop them from escalating. If there is some support and guidance that can easily resolve the problem and bring the employee's performance to the required standard, then that's, of course, the ideal outcome. However, where it isn't working out, giving this feedback can be absolutely key from the perspective of mitigating risks with an underperforming employee or an employee whose conduct is not up to standard. Obviously, if it's a more serious conduct issue, you're likely going to want to terminate for that once it's discovered, rather than allowing the probationary period to continue. But for more minor conduct issues and for performance issues, you want to ensure the employee is aware during the probationary period of the issue and of the improvement required. And this is because by the time you get to the point of saying you've failed your probationary period, there should not be any surprises. If it is a surprise, the employee might say, my performance and conduct is fine, therefore there must be another reason why I'm not being kept on, perhaps a protected characteristic, or I've blown the whistle. If terminating for poor performance or conduct and they've been told all along there's no issues with your performance or conduct, that's going to add to the employee's argument that there is in fact another unlawful reason for termination, even when that's not the case, and the reality is just that they've not been performing well, or there have been issues with their conduct, but this hasn't been communicated to them. So when at the end of the probationary period, the employee says, I think I've been doing a good job, and the business disagrees with that, you want to have something to point to say, no, we've been clear to you about what the standards are, and we've been clear to you about the ways in which you've not been meeting these. And that takes us on to tip number 7, which is document everything. So make sure as far as possible notes are taken of all the meetings and discussions that take place during the probationary period. You don't want it to be the manager's word against the employees regarding what was discussed in the event of a dispute. If an employee looks to raise a claim, you want to be able to provide written evidence to show that expectations were made clear to them, areas of underperformance were highlighted, and support was given to help them improve, but that they still didn't meet the required standards, and that all of this was communicated to them. Moving then to tip number 8, which is diarise the probationary expiry and issue notice in good time. So going forward, you should ensure...
Yeah, I need to phone him today because he was meant to...
Oh, I think there's someone that's got their mute off. Can everyone make sure they're on mute? So going forward, you should ensure that you have the probationary period review meeting in good time, such that notice can be issued sufficiently in advance of the date the employee reaches 6 months qualifying service. It's good practice to always diarise for the notice period under the employee's contract and get the final review meeting in the diary and reminders for this. As I mentioned earlier, you may wish to review your contracts and ensure this notice is a statutory minimum notice of 1 week during the probation. An important point just to bear in mind is that where you're terminating with payment in lieu of notice, it often isn't realised that statutory minimum notice is added to the date of dismissal to work out continuous service for unfair dismissal purposes. So even when you're paying payment in lieu of notice, you need to make sure you're issuing notice at least 1 week in advance of the date they reach qualifying service. Ideally though, I would say don't leave it that close to the wire and plan to have your probationary review meeting and issue notice of terminating much further than in advance of this, in order to allow time for any unexpected issues or delays. Moving then to tip number 9, consider training for managers. So managers are of course key to making probationary period effective. You'll want your managers to be clear on what the probationary period should look like in your organisation, to ensure this is effectively and consistently managed. And as I mentioned earlier, one thing we often see managers struggle with in particular is having those difficult conversations when an employee is underperforming. So training on how to manage those may be particularly useful. You'll also want them to be clear on the importance of regularly reviewing and, as per tip 8, of diarising to ensure that they don't just let things drift past or even too close to the 6 month mark. And linked to training for managers is our final tip, tip number 10, which is consider templates and tools to support the process. So consider whether standard templates for the likes of inductions, review meetings and probation outcomes would be helpful within your organisation. Perhaps a checklist to ensure that key steps aren't missed. Giving managers the right templates and prompts may make it easier for them to get this right in practice and can save time. It also goes back to the point I mentioned earlier about a consistent approach across the organisation, mitigating the risks of discrimination and other day one claims. So to conclude on our probationary period section, effectively managing probationary periods can hopefully set an employee up well for success if they do pass this. And in circumstances where a probation has failed, an employee is perhaps less likely to bring a claim if they understand the reason for this and feel they have been treated fairly. What I would say is look to get your organisation into the habit of effectively dealing with probationary periods now, don't wait until next year. Whilst any new starts from 1st of January will get qualifying service after 6 months, it's important to remember that any new starts you have this year and last year, they will also benefit from that reduced qualifying period from the 1st of January, as at that date anyone with 6 months service will be able to claim unfair dismissal. So with that, I'll pass you to Cara to run through our legal updates.
Thanks very much, Anna. I'm now going to go on to discuss some recent Employment Tribunal and Employment Appeal Tribunal cases, and just discuss some top tips arising out of those. So the first case that we have is on the slide there is Cancanalopi versus Loche Energy Systems Limited. Now, this case is an employment appeal tribunal case, and the appeal tribunal considered in this case whether the withdrawal of a job offer was a breach of contract or not. Now, in this case, the claimant was offered a project manager role in September 2022. And that role had a proposed start date of the 1st of November 2022. Now, the claimant was given a written offer which stated that the employment was subject to receipt of satisfactory references, a right to work check, and successful completion of a 6-month probationary period. But in the written offer of employment, there was no notice provisions that were included within the offer. Now, the claimant went on to accept the offer of employment and completed all the necessary pre-employment paperwork. He provided referee details and supplied right to work documents to the employer electronically. The employer acknowledged the claimant's acceptance and had started to make practical preparations for his start date, including discussing relocation arrangements with the individual as the role involved the individual relocating. Now, shortly before the intended start date of the individual, the employer notified the claimant that the underlying project that they had been engaged to work on had been delayed, and that they were subsequently withdrawing the job offer altogether. Now, the claimant subsequently brought a claim before the Employment Tribunal, claiming for breach of contract and arguing that the employer had terminated a binding employment contract without notice. The key questions that the Employment Tribunal in first instance considered were whether the conditions that were set out in that written offer of employment, for example, the right to work checks, the satisfactory references requirement, and the completion of the probationary period, were conditions precedent, i.e. meaning that no contract had existed unless and until the conditions were satisfied, or whether those conditions were conditions subsequent, meaning that a contract did exist, and when the claimant accepted the offer, the contract existed when the claimant accepted the offer, but that the contract could then be terminated if the conditions had not been met. And lastly, the tribunal also considered whether if a contract did exist and it was silent on the notice requirements, whether a term requiring reasonable notice should have been implied, and if so, what period of notice would have been reasonable in the circumstances. Now, the Employment Tribunal on first instance concluded that the offer was subject to unsatisfied conditions relating to references and the right to work checks, and that these prevented a binding contract from coming into existence. So, in other words, that they were conditions precedent. Now, in this case, the claimant had provided his referee details. The references had not been checked, however. And the claimant had also provided electronic documents for right to work checks, and the originals were required to be provided to the employer before the claimant started work, which had obviously not been done. On that basis, they stated that the breach of contract claim failed. In the alternative, the Employment Tribunal stated that even if a contract had been formed, there was an implied term allowing termination with no notice based on the employer's standard terms of employment. But it's important to note that those standard terms of employment were not actually provided to the claimant. The claimant then decided that they would appeal the decision, so the Employment Appeal Tribunal then considered the matter. And on appeal, they allowed the appeal and substituted the original decision for its own. The Employment Appeal Tribunal held that the original Employment Tribunal had erred in its decision by assuming that the conditions were conditions precedent without analysing the true nature of the situation. Now, the offer letter contained the key contractual terms, and on a proper construction of the offer and subsequent correspondence between the parties, the Employment Appeal Tribunal concluded that the conditions were actually conditions subsequent. They stated that the contract came into existence when the claimant accepted the offer, but the employer retained the right to terminate if the conditions were not ultimately met. They therefore concluded that the employer was in breach of contract by terminating the contract without notice. Now, the Employment Appeal Tribunal also found that the tribunal, on first instance, had taken the wrong approach to the implied notice point. Now, they stated that the assessment of reasonable notice had to be made at the point that the contract was actually entered into, not with any sort of hindsight and not by reference to standard terms of employment that the claimant ultimately had not seen. Now, they also made reference to the Employment Rights Act 1996 and Section 86 of that Act, which sets out minimum statutory notice periods. And they noted that it provides no minimum notice period where the employee has less than 1 month's service, and that it does not displace the common law requirement to give reasonable notice where a contract is silent. Now, taking into account the seniority of the role that the individual had been offered, the length of the recruitment process, the fact that the claimant was going to have to relocate for the role, the Employment Appeal Tribunal ultimately concluded that reasonable notice in the circumstances would have been 3 months. And as I said, the employer was therefore deemed to be in breach of contract by withdrawing the offer without notice. And they ultimately ordered the claimant to be paid 3 months notice pay by the employer. Now, this decision is really a reminder for employers around the risks of job offers and what you sort of set out in those job offers. And it highlights that conditional job offers may still give rise to a binding contract. Now, you should ultimately, consider what you're setting out in your offer letters, and we would encourage sort of a review of those and deciding whether it is that there's an intention and that no binding contract arises until all conditions have been satisfied, or what the intention is otherwise. If a binding contract is to arise on acceptance of an offer, then any notice period will apply to the employment. That will apply to the employment should be set out in the offer letter. Turning then to our next case on the slide there, which is Ellard versus Alliance Transport Technologies Limited. This is another employment appeal tribunal case in which they determined when the duty to collectively consult is triggered. Now, the case, the employer in this case is a business that experienced serious financial difficulties in 2023. And in April 2023, they filed notices of intention to appoint administrators while attempts were ongoing to sell the business as a going concern. The administrators were appointed on the 2nd of May 2023. And on that day, 15 employees were immediately dismissed as redundant. A few days later, on the 5th of May 2023, it became clear that no sale was going to proceed, and accordingly, the remaining workforce of 51 employees were dismissed. Now, the 3 employees who had been dismissed on the 2nd of May brought employment tribunal proceedings and claims for protective awards, arguing that the duty to collectively consult had arisen before their dismissals, and therefore that there had been a failure to collectively consult with them. Now, as most of you will probably know, the duty to collectively consult arises where an employer proposes to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. And in circumstances where there has been any failure to collectively consult, an employment tribunal can award a protective award to each affected employee of up to now 180 days pay. It was previously 90 days pay, but that has since changed. And they can award that for any failure to follow any of the collective consultation obligations. Now, in this case, the employment tribunal had to determine whether this duty had been triggered on the 2nd of May. The employment tribunal ultimately found that the collective consultation obligations were breached in respect of the employees dismissed on the 5th of May 2023. However, it dismissed the claims of the 3 employees dismissed on the 2nd of May. And they had concluded that at that point, on the 2nd of May 2023, there was no proposal to dismiss 20 or more employees. And it placed weight on the fact that on the 2nd of May, the administrators were still pursuing a possible sale of the business as a going concern, and that only 15 employees were dismissed on that date. In their view, the proposal to dismiss the wider workforce, the remaining workforce, only arose once the sale process had fallen through, which happened a few days later. Now, the 3 employees dismissed on the 2nd of May then appealed that decision, and the Employment Appeal Tribunal then subsequently allowed the appeal in full. And it considered that the first instance Employment Tribunal had applied an unduly narrow approach to the assessment of when there was a proposal to dismiss. Now, they determined that the wording in the legislation, i.e. proposing to dismiss, involves an ongoing consideration of future events, even if those events are uncertain or provisional. Now, they criticised the Employment Tribunal for focusing very heavily on the dismissals on the individual days, and for also treating the going concern sales strategy as effectively postponing the consultation duty. Now, on the evidence, the Employment Appeal Tribunal found that by the 2nd of May 2023, there was at the very least a provisional intention that the business would close if no sale was secured. So that meant that large-scale redundancies were being proposed, even if they had not yet been finalised. They therefore held that the 3 claimants dismissed on the 2nd of May 2023 were also entitled to protective awards in addition to the remaining workforce. Now, what this means for employers is that when assessing collective consultation obligations, it must consider the number of employees they're proposing to dismiss over a 90-day window, not just how many people are being dismissed on a particular day. And also, importantly, what this case highlights is that provisional plans can trigger collective consultation obligations, and that a plan does not need to be final or certain. A clear but a provisional intention can be enough to trigger the obligations. Now, as I had touched upon, in April of this year, the maximum protective awards available to individuals for a breach of collective consultation requirements increased from 90 days to 180 days. So this is, very significant compensation that might be payable to employees in circumstances where there has been any failure to collectively consult. Now, in addition to these recent changes, there's also changes coming down the track in 2027 under the Employment Rights Act 2025. And under this act, the government are going to be introducing an organisation-wide threshold for triggering collective redundancy consultation obligations. And it will mean that an employer will be required to undertake collective redundancy consultation when it proposes to make redundancies which meet or exceed that threshold number across their entire organisation, rather than just across one establishment over a 90-day period. A government consultation has been ongoing on what the threshold should be. I think that is now closed, and that we're awaiting the government's responses to that. Now, this organisational wide threshold, it'll apply in addition to the current threshold of 20 proposed dismissals. So that's just something to bear in mind going forward. Turning then to the last case on the slide there, of Tarbuck v Martello Piling Limited. Now, in this case, the Employment Appeal Tribunal considered the scope of protected conversations and improper conduct during protected conversations. Now, the claimant in this case was employed as an estimating engineer. And in April 2024, the employer's managing director called the claimant into a meeting and raised the possibility of him leaving the business under proposed exit terms. And the employer made it clear that the intention was for this meeting to be a protected conversation and protected under Section 111A of the Employment Rights Act 1996. The claimant wasn't given any notice of the meeting, and the claimant ultimately refused the offer that had been presented to him during that meeting, and he was subsequently dismissed in June of 2024 on the grounds of redundancy. Now, the claimant alleged that he had been threatened with redundancy if the offer that was presented to him was refused, and that was denied by the employer. The claimant ultimately brought a claim before the Employment Tribunal, firstly for ordinary unfair dismissal, for unlawful deduction from wages, and also for less favourable treatment based on the fact that they were a part-time worker. Now, a preliminary hearing took place in the case, and the claimant sought to rely upon the meeting that took place, the protected conversation meeting that took place, as evidence in his claims. But the employer, on the other hand, argued that the meeting was a protected conversation under Section 111A, and therefore that the evidence relating to that meeting was inadmissible. Now, the concept of a protected conversation, as a lot of you will probably know, is to allow employers the possibility of exploring with an employee the mutual termination of their employment in return for a financial payment via a settlement agreement, and to have that conversation without fear of anything that is said by either party, but particularly the employer, of anything being said used against them in the event negotiations break down and that a tribunal claim is ultimately pursued. And generally speaking, the default position is that evidence of pre-termination discussions is not admissible in any ordinary unfair dismissal claim. However, if anything is said during that discussion or done during that discussion that amounts to improper behaviour, the negotiations and discussions could be admissible to the extent that any tribunal considers it just. Now, there is a code of practice on settlement agreements issued by ACAS, and within that it includes examples of what improper behaviour may be, and that includes harassment, bullying, and placing undue pressure on an employee. For example, by suggesting that any dismissal is inevitable if agreement isn't reached. The code also states that parties should meet face to face in a discussion at an agreed time and place. So the suggestion very much is that the individual should be given notice, and the code again suggests that they should be able to be provided with a companion to that meeting if they so wish, but that is not a legal requirement. Now, in this case, at the preliminary hearing that I mentioned, the Employment Tribunal held that the employer's conduct was not improper in the circumstances, and that the meeting was protected under Section 111A of the Employment Rights Act. And it ordered that all evidence of that meeting and the discussions that took place at that meeting were to be excluded as evidence in relation to all three of the claims being pursued. Ultimately, the tribunal preferred the evidence of the employer about what was said in the meeting and found that no threats or undue pressure was put on the claimant. Now, the claimant ultimately appealed that decision, and the Employment Appeal Tribunal then considered the matter. And they firstly considered whether the rule in Section 111A preventing protected conversations from being admissible only applied to unfair dismissal claims, or whether it also applied to the other claims such as unlawful deductions from wages and part-time worker claims. And secondly, they also considered whether the original employment tribunal had incorrectly considered whether the employer's conduct was improper or not. Now, the Employment Appeal Tribunal held that the original tribunal had erred in law by treating Section 111A as applying to all claims. And they noted that it is confined to ordinary unfair dismissal claims only and does not apply to claims such as unlawful deduction from wages or less favourable treatment under the part-time worker regs. And they ultimately determined that evidence of the conversation should therefore have remained admissible for those two other claims. Now, they also found that the tribunal had failed to fully assess in the particular circumstances whether there was any improper conduct or not. And whilst the tribunal focused on what was said in the meeting, the EAT decided that it did not consider the broader context of the case, including the allegations that the claimant was ambushed and that he was given no opportunity to be accompanied at the meeting, and that he was also put under pressure. The Employment Appeal Tribunal stated that those matters needed to be assessed in the round and in line with the code of practice. So the EAT directed that the issue of improper conduct must therefore be reconsidered by the tribunal. Now, this case is a useful reminder that any protected conversations do only apply to ordinary unfair dismissal claims, so that should definitely be considered when you are looking to engage in these types of discussions. If the employee is alleging any other claims, then the discussions may well be disclosable and admissible for those types of claims. But in those circumstances, if there is also an unfair dismissal claim, the tribunal should be disregarding any of the evidence led in that regard. They should disregard that for the purposes of determining any ordinary unfair dismissal claim. But ultimately, the evidence will still be out there in a public forum. I think that sort of leads on to, the safest position for employers is to probably carefully consider the code and what that says when holding conversations, and to take legal advice. And ultimately, when having any of these types of conversations, assume that they may well be admissible in tribunal, and be framing them appropriately with that in mind. I'm conscious that we don't have too much more time, so I will just propose to address any questions at this point.
Just looking up through the chat there, I think the first one is if an employer does not currently undertake health screening through an OH provider on conditional offer, would now be a good time to introduce that so that reasonable adjustments and support can be put in place from day one, rather than waiting for issues or concerns to be raised during the probationary period. So yeah, I would first of all just highlight that it's unlawful to ask applicants about their health or their disability before offering them the job, other than for certain prescribed reasons. But yes, once a conditional offer has been made, employers are permitted under the Equality Act to ask health questions and conduct health screening to establish whether reasonable adjustments are required. And yes, it can be helpful to proactively do that so that you can get adjustments in place at an early stage rather than discovering that they're required further down the line. I don't know if you have anything to add to that, Cara. So,
No, I think that covers it, Anna. Thanks.
let's see if there's next. Is there a form of recommended wording for job offers if we want to have no binding contract until all conditions are satisfied? Yes, certainly there's wording we recommend including in offer letters as standard, you know, if you're setting out various conditions to be satisfied, to say that the offer will be withdrawn if they're not. You know, advising on what conditions you might want to include in your offer letter and helping with the drafting of that to ensure there's no binding agreement until they're satisfied. That's something we can certainly assist with. Is the Tarbuck case ongoing, Cara? That's one for...
Yes, my understanding is it is. So the judgment of the Employment Appeal Tribunal was just handed down in April, and I don't think there's any sort of public updates since that point. So I don't think we have a decision yet on, you know, what's been decided since it's gone back to the tribunal to reconsider. So it's probably a watch this space on this one to see what ultimately does happen.
Thanks, Cara. And then we've got another question here. Could a probationary period be extended for a further 6 months? So probationary periods can always be extended as far as, you know, you agree with the employee, whatever the contract allows you to extend by, you can do that, or whatever you then agree with the employee subsequent to that. But the issue we've got now from the 1st of January is that if you extend the probationary period past the point that the employee reaches 6 months service, then if you're then terminating for a failed probation, that will involve a full disciplinary or performance management process. It's not, because that the employee will have unfair dismissal protection. So there's probably, you know, kind of limited value in extending the probationary period past that, which is why we would recommend that in your contracts you look to have a short probationary period. So, you know, and that, I say there's another question there, would you recommend reducing a 6 month period to a shorter period? Absolutely. You know, having that, the probation periods in your contracts as 3 months, I would say, or at absolute most 4 months, with that limited ability to extend, so that by the time you get to, you know, so that you've got plenty of time in advance of the 6 month mark to assess the performance during the probationary period and make a decision on that and issue notice in plenty of time. So yeah, it's, you know, quite commonly we do see 6 months as standard at the moment, but we'd certainly recommend they're much shorter than that so that you have plenty of time to make the decision before the employee gets that qualifying service. I think that's all our questions there, is it, Cara? Have I missed any?
No, I think that's all of them, Anna.
Perfect. Yeah. That's great. Well, thanks very much for joining, everyone. We won't keep anyone any later. That's 1:30. Yes, thanks very much for joining. I hope that was useful. And if there's anything you wish to follow up with, please do get in touch with us or one of your usual Burness Poll contacts. Thank you.